So I'm Dave Sudis. I'm the chair of the Office Pro Bono Public Interest Committee, and I'm very happy that you're all here to attend. The Family Defense Center is one of our 6 core partner pro bono organizations that we work with regularly. So we're very committed to working with the organization. We love them, and so we're glad you're here. Specifically, Bill Essig is a partner in my group. I'm in the Products Liability Group, who has the closest working relationship to the organization. And both Liz, Kristen, and Russ Cheevy have done some substantial work for the organization. So they probably, if you're here at Drinker and you have questions, those are probably the 3 people that you should talk to. And without further ado, I'm going to turn it over to Liz first.
Thanks, Dave. Hi, everybody. I'm Liz Kristen. I'm an associate in the products group here. I joined the firm about 2 years ago, and one of the very first things I was lucky enough to get involved with was a pro bono case through the FTC for a woman named Patricia. What had happened in Patricia's case is that she had been indicated for child abuse after an incident with her teenage daughter. Her teenage daughter had a lot of issues going on, was really going through a tough time. And when we did our investigation and started looking through the facts, it turned out it was really a self-defense issue. So Bill Essig and I took it to hearing, and we were able to get the finding reversed. Patricia was able to get her job back. She was able to get her public housing certificate back. So it was so rewarding. And to be sort of new to the firm as a mid-level senior associate and be able to jump right in and get that litigation experience, putting witnesses on, cross-examining witnesses, delivering an opening statement, it was so fun and exciting, great learning experience. And I think that that's really something that FTC has to offer associates like myself. So with that in mind, I want to introduce Sarah Galloon and Leah Donnelly from the Family Defense Center. Thank you.
Thank you, Liz. Welcome. Thank you, everybody, so much for coming today. My name is Sarah Galloon. I'm the Director of Legal Services at the Family Defense Center, and Leah Donnelly, our staff attorney at the Family Defense Center, will be presenting with me today as well. And thank you so much to Drinker Biddle for hosting us. What we want to accomplish here today is introduce you a little bit to the work that the Family Defense Center does, give you some background and some context on this child welfare world that we work in, how it works, some of the issues, why it's so important, the work that we're doing here, and give you a little bit of background on that. And we're going to be focusing primarily in terms of the pro bono program on DCFS, that's the Illinois Department of Children and Family Services, DCFS expungement appeal hearings, which are the core of our pro bono program, in which after today's training you should feel adequately equipped to take on one of those cases and represent an individual client in their case, in their appeal against DCFS. So that's why you're here, if you weren't sure. I just wanted to start out, feel the where the room is at. Before I worked at the Family Defense Center, I had no idea what DCFS was. I didn't know anything about the child welfare system. So some of you may be in a similar position. So I don't know if anybody wants to volunteer. When you hear Department of Child and Family Services, is there a word or phrase that comes to mind? Okay, I thought that might happen, so I came with some of you may hear that and think, protection, that's the government agency that keeps children safe. Some of you may think investigation, that's the department who looks into people accused of abuse or neglect. Some might think removal, that's also the agency that separates children and families, sometimes rightly, sometimes wrongly. It's very much an under-the-radar system that a lot of people don't know a lot about until they're personally involved or have a client who's involved or have a family member who's involved. So it operates a little bit in the shadows until it becomes a very important part of your life. So we'll get into that more, but to the extent some of you are coming in without a lot of preconceived knowledge about child welfare, you're probably not alone. So the Family Defense Center, broadly, our mission is advocating justice for families in the child welfare system. We're a nonprofit organization, a legal aid organization, and we're privately funded through donations and grants and some legal fees. We don't get government funding. So that's kind of where we're coming from. And I should say there's a lot of information. You all hopefully have a handout of this presentation that I'm not going to read everything on one of these slides, but this is a good resource and has a lot of good sites and information for things that we don't go over in mundane detail today. Our goals at Family Defense Center are, we get involved when Illinois DCFS is investigating somebody, trying to, possibly impairing the parent-child relationship, or seeking to impair someone's ability to work in the child care field. That's when we get involved. You might see Family Defense Center and think, oh, this is going to be a family law case, a divorce, or custody, but actually it has to do with child welfare system. So our goals are helping individual clients in individual cases, but also changing policies and practices on a much broader level. We do that through policy advocacy, through bigger litigation, such as state class actions, federal civil rights litigation, appellate litigation, and some of our pro bono attorneys and firms, as they become more involved with us, take on some of those larger cases. And the focus of today's hearing, we help people clear their names if they've been falsely accused or wrongfully accused of child abuse and neglect. That's what these expungement hearings are all about. And another important reason to do this is obviously, especially in Illinois, government resources are really limited. And our position is they should be focusing resources and services on those families where a child really is in danger of serious harm, serious physical abuse or sexual abuse. You'll find as you come to work with us that most child welfare investigations, the root causes are really just poverty, treated as neglect, or a mom who's a domestic violence victim who's never actually harmed anyone or neglected anyone but is being treated as such because she's been a victim of domestic violence herself, or people dealing with a mental health diagnosis or a substance abuse issue, even if they're treating it, are being wrongfully labeled as neglectful parents. So, and another thing that we do is a lot of the issues have to do with due process. And, as lawyers, we understand more than anyone how important that is. And we're sort of a watchdog to make sure DCFS is following their own policies and other policies, such as the Constitution, little things like that are important to keep in check. So I already touched on a little bit of this, but so we represent people, hundreds of parents and caregivers every year in DCFS investigations, and then after the investigations in administrative proceedings, which again is what we'll be focusing on today. We also bring bigger impact litigation. We do, to the extent we can, policy legislative advocacy. There's a lot of legislation always in the works that really has a big impact on our clients and families across Illinois that we try to keep an eye on. And once in a while, we even collaborate with DCFS. Right now, we have a really exciting domestic violence pilot program that we're doing jointly with DCFS and domestic violence agencies around the state to improve child welfare intervention into families experiencing domestic violence. So that's been a very exciting development. So the work we do in the pro bono program is so important. There is a lack of attorneys who have expertise in this area, a huge lack of attorneys who can help clients on a very low cost or pro bono basis. 2017, we had over 140 attorneys from around the Chicago area, and even a few other states participate in our pro bono program, and we hope to continue that trend. As Liz sort of mentioned, it's a really great opportunity. I view it as very much a win-win for whether it's a law firm or a solo practice and for us, because it's great litigation experience for young attorneys sometimes to work with experts. You get to do a mini trial, whereas in some of your billable work you may not have that opportunity for courtroom experience right away. And on the client, it's an opportunity to hugely impact a client's life. You may, if you clear someone's name off the child abuse registry, they now can coach Little League. They now can volunteer their child in school. They now can continue their career as a nurse. They now don't have that used against them in a private custody dispute. There are myriad negative consequences for these wrongful findings not being overturned. So that's why you should do this. And we'll get into more the pro bono program specifically, but I want to give a little bit of background on the child protection, child investigations world. So when DCFS opens an investigation, which happens after a call to the hotline is made, and Leadin's going to go into that in more detail later, they're basically looking at two things. Is this child safe right now? And is there a parent or caregiver who is guilty? They don't use that term. They use the term indicated. They indicate someone for abuse or neglect. Is there credible evidence that somebody should be indicated for abuse or neglect? And the outcome of the investigation is what we're focused on addressing in these expungement appeal hearings. It goes without saying, the worst thing in the world probably you can be accused of is child abuse or sexual abuse. And it's equally terrible to be falsely accused of that. Families who end up with an unfounded investigation and their names are cleared at the end, the fact of the investigation itself can be really traumatic for the kids, as equally traumatic as if the alleged abuse had occurred. And that's something that people don't always think about. And the best remedy for this, for helping people overcome, such a traumatic experience, even just being investigated and having to clear their name, is effective legal representation at the subsequent hearing. I mean, it's really important to hold the state accountable to actually, follow the policies and practices and due process requirements that are in place. This is just to give you some context. This is national numbers, but there were nationally, there were hotline calls about 7.4 million child victims in 2016, but only 676,000 of those cases ended up being substantiated. So there's obviously good reasons to encourage reporting when people suspect real abuse or neglect, but the reality is it does kind of flood the system with frivolous cases and take focus away from the more serious cases. And the allegations that 75% of those cases were neglect. So, which is really another word for lack of resources, poverty, inadequate child care, and things that have nothing to do with the character or actions of the parent. This is a staggering number. This is from the early 2000s in a federal case that Family Defense Center brought. Before I was there, the federal court did a review of people in Illinois who are indicated for abuse or neglect, who appeal those findings. Over the couple years they looked at, 75% of people won their appeal, which is a staggering error rate. And that's also, our pro bono program has a win rate of over 75 or 80% as well. So something to keep in mind. And thinking about I've had a lot of pro bono attorneys given us feedback they've really enjoyed more than anything else getting to work with a real client, a real person. So we've got just a couple clients who have written into us, and a couple of these are from pro bono cases about the difference that our representation in this area makes. This person said, I've had a successful nursing career for almost 8 years, love caring for people, but most of all love caring for my daughter. To have DCFS called on us when we did nothing wrong was a shattering life experience. Calling your office was the best thing we could have done. You gave us support and guidance in a time it was hard to find our way. We never knew of the problems with the system until we were involved personally with it. I find people to be very grateful that anyone believes in them, much less goes on to win their case. And here's a couple others. The first person worked with people with mental disabilities, so her career was at risk. And the second one was from a mom who, this was a pro bono case, Winston and Strong did, that they won. She says, I can only describe opening that letter from DCFS as entering an abyss of despair. Within a day, you responded to my plea for help. Your prompt response was incredibly comforting. It was like my family had just been hit by a tornado and you were the American Red Cross. You brought justice to my son in 76 days and prevented him from carrying this emotional burden for a lifetime. So hopefully those words give you a sense of how impactful quality representation in these types of cases can be. So at the point at which a case would be referred to you as the pro bono attorney from the Family Defense Center, the DCFS investigation will already be over, and the client will have been indicated for either abuse or neglect. If an administrative appeal is proceeding, it means there's no concurrent juvenile court case where the kids have actually been removed into foster care. There's no concurrent criminal court case because these administrative proceedings can't proceed if those things are going on. And the point of the administrative appeal has nothing to do with best interests of the child or where is the child going to live after this hearing. That's a common misconception. It's really just, was there evidence to indicate this person for abuse or neglect, such that they should be listed on a state central registry of abuse and neglect perpetrators for either 5, 20, or 50 years. So the issue is clearing the person's name, which can have major consequences for their career and personal life, as I previously mentioned. So normally the client will have already filed their appeal with DCFS and will have a lot of the materials ready for you when we refer the case. And appeal is a misnomer in these cases because it's actually the first hearing, first neutral review of the evidence, and DCFS has the burden of proof, even though it's called an appeal. And from the pro bono attorney side, what are the expectations? The expectations are your lead counsel. Often you can do these in pairs or more than pairs, depending on the complexity of the case. We're not going to appear at the hearing with you, but we provide ongoing consultation and guidance and strategizing and templates and everything that you need throughout the case, but you handle the hearing. And we want everyone to always keep us informed of how the case is progressing and any major issues that arise. And we've gotten very good feedback, I believe, about when we refer the case to you, we don't leave you out there on an island. I think for the most part, our pro bono attorneys have felt very supported. If they have questions about procedure or substantive issues, that's what we're there for. A specific, either Leighton and I will be the point person for your case, so you're not in the dark. A little bit about the legal framework. I'm not going to read all of this, but the Illinois Abuse and Neglected Child Reporting Act is what gives DCFS the authority to do these investigations. The Juvenile Court Act, which doesn't govern these cases, is what governs parental rights, placement of the child, and things like that. And here's a better way of, I should have read this than whatever I stated out before, but these hearings are deciding whether a parent or caregiver should remain listed on the state central register of abuse and neglect. So that's what's at issue in these hearings. And then there's a couple cases that we're going to talk about as examples throughout, so I'm just going to give you the facts now for this one. This is a case we did a few years ago that a pro bono attorney handled with us. Jordan and Melinda had 3 daughters. They now have 4 daughters, so Jordan's really outnumbered. But at the time, they had 3, ages 4, 3, and 1. They did not get along well with their neighbor who called DCFS and made a false report that they'd let the girls play unattended by a kiddie pool in the backyard. In actuality, that never happened. They'd only used the kiddie pool once, and the parents were supervising them the whole time and taking pictures. With Jordan, who isn't the most well-spoken person, whose words got twisted around a little bit by DCFS, which happens a lot, and were misrepresented in DCFS's notes, what he actually said is sometimes when we're in the driveway packing up the car, the girls are in the backyard playing for a couple of minutes within an earshot. And that all got twisted around. So that led to an investigation, and they were both indicated for neglect in the category of inadequate supervision, and that's the point at which they came to our office. And this is the pool, and they were supervised because Melinda took this picture, and as you can tell, can't even tell if there's any water in that pool. But that gives you a little bit of context. And Leighton's going to talk about another case as well as a little more info on the DCFS hotline and investigation.
Hi, everybody. My turn to talk. So this case example is Eva R. Eva was and still is a single mother. She doesn't have any more kids unlike Jordan and Melinda. To at the time, 3.5-year-old son. She and her son were staying over at a family member's house. They were both asleep. The son woke up in the middle of the night, climbed into his mom's bed, fell off the bed, and burned himself on the radiator next to the bed. She then woke up. She put ointment on the burn, comforted him. Everything was fine. Several months later, his school called DCFS saying that the burn was taking a long time to heal, which, anyone can recognize on the face of it that is not an allegation of neglect, but also that Eva wasn't watching her son when the burn occurred. Eva explained that she had been asleep when the burn happened. DCFS indicated her for neglect anyway for the allegation. There's a specific burns allegation, burns by neglect. Okay. So again, we'll revisit those cases. That's just to give you an introduction to them, and we'll come back to them when we talk about how to handle cases when it actually comes to the hearing. So now we're going to back up a little bit and talk about the DCFS investigation. This is just background info for you guys. You're not going to be representing people during investigations, but it is helpful to know a little bit about how the cases get to the point of the indicated finding and the administrative hearing. Okay, so the first step, the hotline call. We've already mentioned this. There's a statewide hotline that people can call to report suspected abuse or neglect. Again, just like the national picture, there's many more calls than there are substantiated reports. There's actually even many more calls than there are investigations because only about 30% of the calls that were made in DCFS's fiscal year 2017 even met the criteria to be investigated. So you're getting a lot of calls that are just, sometimes people call to say like, where can I access services? Sometimes they call and say like, I don't like my neighbor, I don't think they're a good parent, but they're not saying anything specific. So those wouldn't be taken for investigation. But a lot are, and a lot of people, unfortunately, will use the hotline as a weapon in family disputes. We see that a lot, and it's very sad. The hotline can be used to refer to a bunch of different things. We've already discussed it's a phone number. People also refer to the actual state central register, which is where indicated reports are kept as the hotline. And in that case, it functions as an employment and licensing blacklist for people who want to work with children. Okay. So when a hotline call comes in, a DCFS employee is responsible for screening it to determine if the case meets the standards for investigation. We actually do a similar thing at our office when a call comes in for our help. We also have, a few questions we ask to figure out if it's the kind of case we can take. So the answer to all these questions has to be yes, or they won't refer the case for investigation. The first question, is there a child? It has to be a current child. You can't call DCFS about something that happened 30 years ago when somebody was a child. They just don't have the authority to investigate that. Is something alleged? Again, are you calling to say, I don't like how my neighbor parents, or are you calling to say, my neighbor did something specific that I think might have been abuse or neglect? Does what is alleged fit within one of DCFS's allegations of harm? So you've already seen two examples of those allegations, the burns by neglect in my example, allegation 74, inadequate supervision in Sarah's example, and Sarah's actually going to go into some of those allegations a little more deeply later on. But basically, it's DCFS's way of getting a little bit more specific than the very general definitions of abuse or neglected child that are within the law. And then finally, is there an eligible perpetrator? I will discuss what that means in the next couple of slides. It's a little bit complicated. If the answer to all these questions is yes, the case is accepted for investigation and sent to the field. Okay, so eligible perpetrator. DCFS can't just investigate anything. They have very specific enumerated powers given to them by their enabling statute. And so they only have the authority to investigate and indicate a person for child abuse or neglect if that person has a special relationship to the child. So for abuse allegations, it's basically anyone who's responsible for caring for the child's parent, or a household member or immediate member of the family. For neglect allegations, it's only the child's parent, guardian, foster parent, or a person responsible for the child's welfare at the time of the alleged neglect. So examples of people who aren't eligible perpetrators for neglect, that's anyone not in a caretaking role for the child. So a roommate, a sibling, a neighbor, any other person not currently tasked with caring for the child at the time that the alleged incident occurred is not an eligible perpetrator to be investigated. So DCFS can't investigate like an 11-year-old sibling for inadequate supervision for failing to watch their, other 12-year-old sibling. Like that, DCFS doesn't have that authority. Also, that's ridiculous. So for abuse, anyone who's not an immediate family member or a caretaker isn't an eligible perpetrator for abuse. So, for instance, a cousin who isn't a household member or a caretaker, or a random store employee who has no relationship to the child. It's possible that one of these people might, very sadly do something to the child that if they were a parent would be considered abusive. But because they don't have that relationship to the child, DCFS isn't the appropriate authority to investigate those claims. Yes?
Are these guidelines just for Illinois, or are they?
Yeah, this is all Illinois specific. I think pretty much every state has something similar, though.
Thank you.
And so there can be concurrent criminal investigations of any of these allegations. So just because somebody can't be investigated by DCFS for something doesn't mean there can't be a criminal case if it warrants that. Yeah, so DCFS only has that specific authority. If we notice an issue with an eligible perpetrator, we try to flag it for our pro bono attorneys, and we do see those issues sometimes, and that warrants a special motion usually. Okay, who is the field? I mentioned the field. These are the people who are involved in the investigation. DCFS is required by law to see and assess the safety of the alleged child victim within 24 hours of the hotline call. So they'll send out whoever's on duty at the time. Usually this will be different from the eventual investigator who's assigned to the investigation. The investigator has a supervisor, and then there's also an area administrator who oversees several different investigative teams. The investigator is the main person who will be interacting with the client and gathering the information during the investigation. They don't have strict requirements to become an investigator. They have to have a college degree and some social service experience. I think they maybe recently changed it to also allow criminal justice experience. So they have a lot of turnover, and they'll take whoever they can get that meets their minimum requirements. And their training is not great. Only about 50 hours to get started. We sued DCFS, they changed the rules, and they don't necessarily retrain their employees, which is unfortunate. Okay, so after the case has been assigned to the investigator, there are certain required steps that the investigator has to take. This is something that you do want to pay attention to as a pro bono attorney, because if the investigator didn't take these required steps, that undermines their credibility and also the credibility of the eventual decision they made to indicate the client. So something we see in particular is that investigators often won't make in-person contact with the alleged perpetrator in a timely manner. They often won't share the details of the allegation of what the person's being accused of with the actual person who's being accused. And that prevents them from gathering exculpatory information, which they're required to consider. So if you don't tell someone what you're investigating them for, they can't really tell you why that's false. So we see that all the time, and that is important to take a look at, because if you have that in your case, you definitely want to cross-examine the investigator about that and be like, why didn't you bring this up with them? This is why you didn't do a good investigation. And do it a little bit better than that. That's not a good example of cross-examination. Generally, investigations take 60 days, but they do pretty liberally grant extensions. It's supposed to be for good cause, but we see some pretty liberal extensions granted. This is another FYI slide. You may, as a pro bono attorney, see that there has been a separation of the parents from the children during the investigation. By the time the case reaches you, that should be over. But we do get a lot of pro bono attorneys coming to us and saying, like, was this okay? Like, this happened during the investigation. Can I bring this up at the hearing? Like, this is crazy. Long story short, the judge isn't really going to care about it at the hearing. The hearing is about the ultimate question of whether abuse or neglect occurred. not how badly did DCFS behave during the investigation. But safety plans are one of the core areas that we focus on in our advocacy for parents during investigation. So it's a big part of what we do as an organization. So I will just give you like a quick overview of what they are. Basically, a safety plan is supposed to be a voluntary agreement that a parent enters into to restrict their contact with their children for some period of time. And the idea is to avoid having to go to juvenile court and have protective custody taken of the kids. So it's supposed to be a short-term plan to mitigate an immediate safety risk. In practice, we do see that these safety plans are implemented in all sorts of illegal ways for long periods of time. DCFS is only supposed to even ask for them when they have grounds to take protective custody because it's supposed to be an alternative to protective custody. Unfortunately, they will often tell parents that they're required to enter into safety plans even if there's no grounds for protective custody, and they won't explain that it's voluntary. This is what's wrong with safety plans. You guys can peruse that at your own leisure. And if you want more information on safety plans, we're happy to talk about it. There's information on our website. We could talk all day, but that's not what this is about. So I'm going to let us move on to the next topic.
I wanted to give a little overview of what are the rules and procedures and where does that fit into the framework, the rules and procedures that govern these investigations, as well as the administrative appeal hearings. And I should add, hopefully everybody picked up the other handout, which is our pro bono attorney manual, with a new date of today, hot off the presses, first revision in many years. So there have been some updates to the DCFS rules lately, and so that goes into even more detail on where to find them and the ins and outs. But that's a really good resource, whether you're thinking about taking a case with us or while working on your case. As an administrative agency, the Abuse and Neglect of Child Reporting Act, or ANCRA, that we referenced earlier, is what gives DCFS its authority to investigate. And then DCFS creates its own administrative rules under the Administrative Procedures Act. They go through a public notice and comment period that kind of flesh that out. And sometimes they flesh it out in a way that we think is illegal, but that's the general framework. And then they also develop procedures that don't have to go through a public comment period that are even more specific to what their employees are supposed to be doing during an investigation. So, and these are all, it's cited even more closely in the manual, but these are all on DCFS's website. The Illinois Administrative Code is where the rules are kept, and their website is where their own procedures are kept. There's a Rule 300 and a Procedures 300 that goes along with it that governs what they're supposed to do during an investigation. Appendix B of that rule is where DCFS defines all of their different allegations of harm, which are numbered 1 through 86, I believe, and it contains specific definitions for each category. And then Procedure 300, Appendix B, fleshes those out even more. And then Administrative Rule 336 is what governs the expungement hearing process that we're talking about. So exchange of information, witnesses, how do these hearings function, role of the administrative law judge, all that is covered there. And that's something you'll constantly be referencing throughout your preparation when you handle one of these cases. So an allegation, the two examples that we gave were both neglect allegations. Some allegations are abuse, some are neglect, some can be either abuse or neglect. The burns allegation, if a child has a burn, they could be indicated for burns by abuse. If the accusation is that they intentionally and abusively caused the burn, or neglect, where obviously when the child fell out of the bed, that wasn't an abusive action taken by the mother. At most, the allegation there was due to some neglect on her part, the burn happened. So just a few examples. There are some that can only be abuse, and they really are the more serious sexual allegations that mostly fall into this category. Sexual penetration, sexual exploitation, very, very serious allegations that someone can't commit through neglect, which makes sense. And then some can only be neglect, and they mostly have to do with lack of supervision, lack of food. There's a medical neglect allegation, about environmental neglect, which refers to the conditions in the home and whether or not they're sanitary. Those can't be abuse, can only be neglect. And then there's some, such as burns, that can go either way. Bone fractures is another one. You know, a child might have a fracture that the allegation is, you know, there was an accidental fall that what some other parents thought would be neglect, or they're saying it was an abusive action intentionally caused by the caregiver. So there's several that can go either way, and you'll see that come up a lot. Pop quiz. Where can you find the definitions of the various allegations of harm? Anyone? That's not one of the choices. This is my one animation here. Appendix B, DCFS Rule 300, Appendix B. So the reason that you'll be referring to these constantly throughout the hearing is oftentimes there are some requirements of DCFS that are more critical than others for them to follow. But sometimes their failure to properly apply both the rule and the procedure, you know, can really undermine their basis for maintaining the finding. Especially the definition in Rule 300 Appendix B. Some of them have very specific elements, require verification by a physician. If it's not there, they lose their case. You would think that that would be taken care of and they would have never indicated the person in the first place, or once it gets to administrative hearings, they would realize it and throw it out before the hearing. Wrong. They often will make you go through the entire hearing and then decide, oh, you're right, there was never verification by a physician. So these are things to look for all throughout the way. There are certain common mistakes that the DCFS investigator makes: failure to contact this person, failure to get medical records, failure to document, and the procedures and rules really lay all of that out. At the end of an investigation, as we've mentioned, it could be indicated or unfounded. If it's coming to you, there's been at least one allegation indicated, and the person has 60 days to file an appeal. Almost exclusively, that'll have already happened. There could be exceptions where we get it so early on, and for some reason we have enough information to refer to a pro bono attorney prior to that, but almost invariably, the appeal will already have been filed. What is the evidentiary requirement to indicate somebody during an investigation? Unfortunately, it's not very high. It's basically a standard of, is there credible evidence, or as they explain in their Rule 300, that would cause a reasonable person to believe that a child was abused and neglected when viewed in light of the surrounding circumstances. It really gives investigators broad power to indicate somebody. When you get to the hearing, the burden is preponderance of the evidence. They have to show it was more likely than that. They do, Dupuy refers to a case, the same federal case that we brought that has led to a lot of different procedures that DCFS is supposed to implement now. They are required to consider favorable exculpatory evidence, but it can be a problem. People don't necessarily know they can submit that. They aren't given the opportunity, but sometimes that's a huge factor in winning the hearing, because the exculpatory evidence was investigated, found, considered. So that's a huge thing to focus on in these hearings. People who work with children, a teacher, a nurse, daycare owner, somebody who works in the mental health field, and the nanny even can qualify. During the investigation, they're supposed to be given some extra protections. And these are issues that if they came up in your case, we would certainly flag it for you from the outset of the pro bono referral. But it's a good thing to be aware of. They are entitled to an expedited appeal. Those often don't come up in pro bono cases because it's not the expedited cases either we handle or we have other referrals. Once in a great while, a pro bono attorney will be able to do one on an expedited basis. But it doesn't come that often. But it makes sense that somebody whose career is going to be impacted would have the opportunity to have a decision reached much quicker on their expungement appeal. The length of time that a person's finding is maintained against them varies greatly depending on the allegation, and makes a huge difference in how much is this finding impacting somebody's life. Certain allegations, death by neglect or sexual penetration, sexual abuse allegations, person would be listed for 50 years on the registry. And just bear in mind that a person could be indicated by DCFS for sexual penetration, and if they're able to request an administrative expungement appeal, it means there were no criminal charges or they had a criminal trial and were acquitted, and yet they're still on this sexual registry. So, in some cases it may be appropriate, but or it may end up, it may be that it actually happened, but it's something to keep in mind. Whereas if they were convicted criminally, they don't have the opportunity to appeal. So as horrible as it sounds, it's equally horrible to be listed for 50 years as a sexual abuser of a child if it isn't true. Some allegations are mandatory 20 years. Failure to thrive, which has to do with infants' troubles with gaining weight, or some of the other sexual allegations. There are some that are mandatory 5 years only, inadequate supervision, environmental neglect, most of the neglect categories. And there's some where the investigator has major discretion to indicate the person for 5 or 20 years, and that's actually an issue, can be an issue in the appeal as well. Sometimes a 20-year finding, we may not win outright and get it expunged, but may get it reduced to a 5-year finding, which is still a huge win for the client depending on the circumstances. And there are various factors that come into play, but we don't, in reality, the reasons for using one or the other are very apparent, and it does seem to be a little bit random and unlucky depending on the investigator. And now we're going to go into what these hearings look like. I don't know if you can read this, but we like this, which I call a helpful tip. The proof was in the pudding, but the pudding was rolled inadmissible acceptance.
So hopefully you guys find this helpful. You can refer back to it in your materials when you're preparing your own case. Okay, how does a pro bono case start? Now we're actually talking about the stuff that's relevant to you guys as pro bono attorneys specifically. So we don't just refer any case to you. We have an internal screening process where we decide whether the case is appropriate for pro bono. So we review the case for merit, defenses, impact on the client. That's something that we consider, is this a 20-year finding, is this a 50-year finding? Obviously those get big priority because that's a huge impact on the client. Other client factors, we also consider sometimes if the client is, their job is being affected, that's also something that would make the case more of a priority for us. Policy impact, yes, we review the file to see what sort of evidence DCFS actually has against the person. And then, of course, we determine that they're financially eligible for pro bono. We hold weekly case review meetings where we discuss and we have consensus decisions to refer these cases to pro bono attorneys. So at the point that it comes to you, we've already done all of this and determined that the case is most likely going to be a good one for pro bono. Okay. As we've stressed several times, by the time we refer the case to you, the client has already filed their appeal. It would be a very, very rare case if they had not. So we already know what has been indicated, the specific allegation of harm, and we have the DCFS investigative file. So usually what we actually do is we review the file, we go back to the client. If there's anything where we're like, oh, it says it's in the file, this is different from what we thought, we get some of those answers and flesh it out a little more, and then present those notes to you when we refer the case. So some of that preliminary work has already been done. Okay, so then the actual hearing process has 2 steps. Sometimes this is like a little bit of a misnomer. Technically there's 2 steps. There's a pre-hearing and an in-person hearing. It's typical to have several pre-hearings before you get to the hearing. You don't need to. Sometimes people will have one, go straight to the hearing. But usually people will have a few because the primary purpose of the pre-hearing is scheduling, and sometimes people need a little extra time to discuss pre-hearing resolutions, to look at the evidence more, to figure out witness availability. So you might need to have several pre-hearings before you can actually finally schedule the hearing. By the time we refer to cases to you, usually there's a date for a pre-hearing but not a date for an in-person hearing. Occasionally we will get people who come to us and on their first pre-hearing they just set an in-person hearing. That can be undone. It's pretty easy to advise a client, call the ALJ, ask to reset it for a pre-hearing. And we'll get into the reason why DCFS does this, but basically they've got some obligations, speedy trial obligations, so they do sometimes inadvertently pressure clients to set a hearing date quickly, but they're very open to resetting it if you request it. So the governing statute for the actual administrative hearings, there's a small, tiny section in INCRA that says the subject shall have the right to a hearing within the department to determine whether the record of the report should be amended or removed on the grounds that it is inaccurate. And that's it in terms of the actual law. Everything else governing the hearing is contained in the administrative rules. Rule 336, which was recently amended, is the rule that lays out everything about the process for these administrative hearings. Okay. As we've mentioned, the department carries a burden of proof by a preponderance of evidence at the hearing. Sometimes the ALJ, the administrative law judge, will say, okay, the department has a burden of proof, so you don't even need to put on a case at all. Like, if they don't do a good job, you can just not put on any witnesses. That's really bad advice. I hate that they tell people that, especially pro se people, but obviously I'm sure all you guys realize that even if the other side has a burden of proof, you still should consider it as having to affirmatively show that your client did not commit abuse or neglect. Okay, so where to start? Prior to the pre-hearing conference, you should, assuming you have the time, sometimes you'll have a pre-hearing conference you have to appear at, next week, and you don't have time to review everything. At that point, you can, of course, request, Judge, I just got this case. Can we set another pre-hearing, in a few weeks, in a month, so I have time to review the case. But you should ideally read through the investigative files so you get an idea of what DCFS is saying they have on the client. It's a record of all the contacts that the investigator made during the investigation, and it also contains some additional evidence. Usually we'll see medical records, sometimes letters from various witnesses. But the meat of it is really the contact notes. And then, of course, review the specific allegation that your client's been charged with. Sometimes you'll do that and you'll realize, even their own file doesn't demonstrate the facts to meet this allegation. And so that's, of course, important to know. Review our training material. You're at our training, but we have much more information in our pro bono manual. So that can hopefully be very helpful on some specific questions. Meet with the client, file your appearance, and then, begin putting together, getting an idea of your witness and exhibit list. This should be submitted at least 14 days in advance of the in-person hearing date. That's not actually in the rules anywhere. That's just best practices. What is in the rules is that you have to give this evidence to the other side. Let them know what witnesses you have. Give them your documentary evidence you want to introduce within 10 days of a request for production from the opposite side. And then something else that you might want to consider doing, especially if you take a look at the evidence DCFS is claiming to have, and you take a look at the allegation and you realize that it doesn't meet the standard, you can consider advocating with the DCFS attorney for what's called a voluntary unfound. So we've discussed that being found guilty is called being indicated. Being found not guilty is called being unfounded. So the department attorneys do have the authority to just agree to drop the case prior to the hearing if they feel like they can make a good enough case to their supervisors, and actually also to someone on the investigative team has to weigh in on that as well. So, if you get to the point where you're considering this, definitely come and talk to us. We have lots of thoughts on how to do it. Basically, you want to give them all the help you can give them in making this case to get the voluntary unfound, because Sometimes they'll even put in a request and it'll get denied. So you want to help them make it as strong as possible if they're indicating to you that they're leaning in that direction. And then, of course, after you've done all this stuff, you should appear at the pre-hearing and handle it. Okay. I did not go to the next slide. I was like, isn't this the same slide I just read? Okay. So as we discussed at the pre-hearing, the main purpose is to set the hearing date. There are some other things you can handle on the pre-hearing. It's a conference call. It's started by the administrative law judge. He or she will call you and the DCFS attorney, conference you in together. And it's usually really short, unless there's some sort of unusual issue. So an unusual issue would be, for example, a motion you filed that you want to argue. If you filed a motion about your client not being an eligible perpetrator, that's an example of an unusual issue that will be addressed at a pre-hearing conference. So in that case, you might be making an argument. It might be a little longer. In the normal case, pre-hearings will be, 10 minutes maybe. Usually by the time you get the case, the client will have had a pre-hearing already. Usually, not always. But so if they have, you won't even need to worry about this step, which is where the ALJ will verify, okay, you've been indicated for these allegations. There's no criminal case pending. There's no juvenile court case pending. But if you get the case really early, you might go through that. And the ALJ will usually advise parties to exchange their witness and exhibit lists and any exhibits that will be used at the hearing. Some ALJs will also give you timelines for that. Most don't, but some do, and that's actually nice when they do that. It's a little more professional, I think. Okay. So as we discussed, DCFS does have some requirements, like speedy trial limitations on them. So for child care professionals, and again, that doesn't just mean like daycare workers, it's anyone who works in a job that requires that they not be, that they work with children as part of their job and that they not be indicated in order to keep their job. So it can mean doctors, it can mean nurses. Those are two very common ones we see. And then, of course, teachers, daycare workers, people like that. If they fall into that category, DCFS is required to provide them with a final decision of their hearing within 35 days of the date that they filed their appeal. So that's a very, very quick turnaround. If it's not a child care worker, just a normal person, the limit is 90 days. And in both cases, if the appellant either requests or agrees to a continuance, that will stop the clock for DCFS, and that time will count against you. So sometimes, we like to emphasize this because we like that this is a limitation on them. If they do violate these requirements, then they are supposed to expunge the case regardless of the facts of the case, like just as a remedy for violating the due process rights of the person. But you do want to try to win the hearing. So if you do need to request a continuance, you shouldn't be scared out of doing it by lying. This is something to weigh, something to consider. Do I need to request this continuance? Let me consider how it's affecting the client's due process rights. Of course, discuss it with the client, but don't, we would never want you to rush to a hearing you're unprepared for simply to try to satisfy lying. But, something to keep in mind in terms of tricky language is, first of all, don't offer a hearing date yourself. This is a good rule of thumb. Never offer a hearing date. Ask them for the hearing date. You can say, I'd like the first available, or, what hearing date do you have available? And then if asked whether you agree to a date, say you accept the date, not that you agree to it. In practice, the ALJs always make continuances. They always mark that they're by agreement, even if they're not. So it's on you a little bit to build the record on that. If there's, if DCFS comes forward and says, we're not ready to go to this hearing date, we're not ready for this pre-hearing, can we have a continuance, and you don't have a reason to agree to it, you can just say, we don't agree to that continuance. You'll probably still get a piece of paper that says you agreed to it, but then you've got that on the record because all of this is recorded. I did not say that, but it's true. Everything is recorded. Okay. I think this is my last slide here. Yeah. Okay. So this is a recent rule change about whether children can testify at these administrative hearings. Previously, the rule was that for any child under the age of 14, you had to show certain things. They changed it, so now the rule is that for any minor, anyone under the age of 18, the burden is on the requesting party to show these certain things. So first of all, they have to be an essential witness. There's no other way to obtain the information. And the likelihood of emotional harm due to testifying can be minimized, and that the testimony is necessary for the interests of justice. So as part of that change, they've actually listed in the rules ways to minimize this likelihood of harm. So they've specifically said that the ALJ can use any mechanisms that are used in criminal, juvenile, or civil court to prevent this harm to child witnesses. So that could include, in-camera testimony. There's a list of other things. So that is a little bit positive in a way because it is giving you an idea of how you could get this testimony in if you were trying to. Overall, we're not happy with this. We think it's very, negative, bad idea. But
Unconstitutional.
Unconstitutional, yeah. We're just waiting for the right case to sue on this. But in a lot of cases, you don't necessarily even want to call the kid as a witness. So where this comes into play a lot is for kids who are really close to age 18, teenagers who might be making up allegations because they're mad at their parents, and then to say, like, oh, they shouldn't have to come in and testify. We're going to treat them as if they're a traumatized 6-year-old. Like, that's very problematic. So if you have a child witness that you want to testify, definitely discuss that with us, and we can discuss, is it a good idea to push on this? What are some ways to do it? It's always good to consider alternatives as well. A stipulation with the DCFS attorney or written affidavit might be good, especially if you're talking about younger kids, kids who are under the age of 14 and wouldn't have qualified under the previous rule even. And of course, kids who might be traumatized by coming to the hearing. That is a real concern, and we actually, I actually just had a client who DCFS was trying to call her daughter to testify, and she was like, that's going to traumatize my daughter. And I was like, look, the rule has changed. They need to make an affirmative showing. So we don't know. We'll see how that turns out. But it should apply to them as well. Yeah.
I'm going to talk a little bit about preparing your case and things to focus on and getting ready for the hearing. But I did want to add, probably one of the areas we get the most questions from pro bono attorneys, especially at the beginning, is what do I say on the pre-hearing and what's up with this 90-day rule? Do I need to accept the first date? So we lay all that out because it's really important that if a person, especially if they're a child care worker, if they request an expedited appeal and they accept the first offered date, they're getting that decision within 35 days. Most pro bono cases, though, the client has already had to ask for several continuances to allow them time to find an attorney, and it's much, much more important for them to have an attorney who has time to prepare than to worry too much about rushing the date. So in reality, the scheduling is flexible at the attorney's schedule. The tips we even mentioned are still good ones. You ask for their first available date. If that doesn't work for you, that's okay. You ask for the next available one and settle on one that works. And it's important, some of the language is important. In reality, if they've gone beyond the 90 days, even excluding continuances that our client agreed to, they don't expunge right then and there. That only ever happens once we lose the hearing, we file for further review in the circuit court, and sometimes win on that ground. So it's not so automatic as we'd like it to be. DCFS doesn't enforce that usually affirmatively, but it's a good thing to make a record. But wanted to bring it up because usually the point is getting to a pro bono attorney, the client is certainly more concerned about having a good pro bono attorney, a date that works for them. And if there are issues, depending on the person's career or certain scheduling, we always discuss those up front. And that's an area I have tried to flesh out a little bit more in the revised manual, so if you have questions about that, take a look there. So preparing your case, the DCFS investigative file is a packet. and Lita described it a little bit. Contact notes, their rationale for maintaining this indicated finding. Sometimes other documents they gathered like medical records. They've often, though, failed to gather medical records and other relevant documents, but it is their case. That, and if they have some other documents on their witness list they'll have to provide to you, there aren't usually too many surprises at the hearing. The statements in there are what they're going to be relying on. And so you really want to read that carefully. I find in these hearings, because you don't have an opportunity to take depositions and get the person's testimony ahead of time, so you kind of just have to think on your feet a lot, is to just have a really good knowledge of the facts and the dates forwards and backwards. It allows you to respond much more quickly. So the investigative file will say the narrative of the hotline call. There's a little section toward the front called narrative, and it's the person who called the hotline. There's a person at the hotline just taking that down pretty much verbatim. So that's what that is. That isn't evidence. That's the original call into the hotline. Then there's a section listing out all the different allegations. Sometimes one will be unfounded, but one will be indicated. And sometimes they've failed to consider exculpatory evidence. Sometimes they've listed exculpatory evidence as their reason for indicating. These are often very, very lacking, very nonsensical at times. If they're really, really lacking, then sometimes it is, that's when it's the most probable to convince the DCFS attorney to voluntarily unfound the case when they can see from their own case they're not going to be able to win this hearing, or there was really no evidence here to begin with. So the rationale and the contact notes that the worker has made throughout, especially their conversations with their supervisor, will be in there as well. That's another area where they talk about why are we indicating this person. So that's another area to really look at. Did they have anything here? What is this based on? Oftentimes there'll be the last contact note will be a final supervisory consultation with the supervisor and the investigator, and they'll mention some hearsay statement from the hotline call that was never verified by anyone throughout the investigation. Well, they can't rely on that. So it's just really important to go through that very closely and see what areas we can take issue with while looking at the procedures and the rules and the definition and everything that we've been talking about.
A quick question.
Yes.
Hotline call is then recorded, and is there any access to the recording?
I don't believe they are recorded. I've never heard that. So no, they're just transcribing it, the person, the hotline operator. So there is no recording that we're able to access.
I have a question too. Can the caller be anonymous?
The caller, that's a very good question. So under the law, the identity of the hotline reporter, the hotline caller, is confidential and anonymous. Sometimes the person calling in actually won't give their identity and it's actually an anonymous reporter. Normally, especially if it's a mandated reporter, such as a doctor or a school counselor, DCFS will have all their information, but that's actually something that's going to be redacted out of the file, redacted out in black. The reality is it's very easy to tell who the person is unless they were actually anonymous, because when you get to the page where the investigator is then required to call that person and verify again with them what they said, and there's a little black line as under that, it'll have the person's name, and then it'll be blacked out what their role in the case is. So they don't hide it very well. So it's not something that you're supposed to mention during the hearing as, oh, this person called the hotline, but it's very obvious who they're relying on to verify the hotline report.
But can a caller say, I'm not going to give you my name, but I'm not going to say who I am?
A person can do that, yes. Now, that makes it a little bit harder on DCFS to prove their case, especially if that person isn't willing to testify or doesn't give any contact information, then they can't use anything affirmatively from that person. But that does happen. So the main examinations to focus on during the hearing are, in your case, it's going to be your client. Unlike a criminal proceeding, a client not testifying can and is used against them. During the investigation, it's used against them. It's seen as non-cooperation, although sometimes they were never contacted and didn't even know about the investigation. But the judge is going to want to hear from your client, hear their side of the story. There are some cases, they probably aren't going to be the pro bono cases we're referring, where there may be a good reason for that person not to testify. Usually that means, could there be a criminal case still in the future, or if the testimony didn't go well, could they open a criminal case, which would be a limited set of cases. But normally it's going to be your client. How credible do they seem? You may have some character witnesses. You may have some doctors. And then the most important cross-examination is going to be the DCFS investigator who's going to come in, and sometimes they won't remember a thing about the case and they're kind of relying on their notes. And sometimes the supervisor will come in as well if they were more involved in the investigation. Sometimes if they're relying on a doctor, that can be a really important cross-examination. But those are the main ones. And we always discuss and highlight with you in a given case what we think initially the most important witnesses are. And in preparing the investigators cross, and we have some templates and things that we can share as well, there are certain areas that we focus on and pick apart and attack based on what we've been talking about today. You don't want to bring in a parade of character witnesses. The judge will probably tolerate one or two people who can testify to the person's good parenting, or maybe have spent a lot of time with the family, but they don't have knowledge about this particular incident. It's important to have a couple of those if they're available, but you can't go overboard on the character witnesses. This is, very case specific, but it's just a good idea to have a DCFS on their witness list. Often just lists every single person who's named in the file. It could be 20 people. Often I'll talk to the DCFS attorney and say, okay, what witnesses are you actually going to call? Can you either provide an updated witness list or just tell me? Because they're normally only going to call a handful of people. So that's something to look for as well. And we have in our materials samples of these witness lists, certain standard motions, and a subpoena request. For subpoenaing witnesses to come testify, DCFS sends out the subpoenas. We just fax a request to the administrator at DCFS who sends the subpoenas out. And we talk about sometimes whether it makes sense. If you're subpoenaing, if your client has a mother who's really supportive and she's planning on testifying, she's coming of her own volition, we normally don't send that person a subpoena because it scares people and it's not needed. But usually for professionals and other things, we do request a subpoena. So just getting back to some case examples in terms of strategies that we use. This is the case we talked about earlier with the kiddie pool and some of the things that were focused on in the hearing. This was a really sloppy investigation. DCFS didn't properly take into account, as they're supposed to, the hotline caller. Does that person have a bias? And here this neighbor had also been a co-worker of Jordan's, and I think she was fired, and she certainly had an axe to grind and had no knowledge really of the circumstances that she was claiming, but that wasn't thoroughly investigated by DCFS. The investigator, when he came out, noted in his file there was a kiddie pool in the backyard, but didn't notice that it had been turned upside down, didn't verify with the family they'd actually only ever used it once. It was very sloppy, so those were easy things to point out in the investigation. In this case, actually, it's a timely example to be talking about. Once in a while we'll have a pure legal defense that we're raising, and in these, for several years in these inadequate supervision cases, we were raising the allegation that this allegation, DCFS's definition in their administrative rule, is void as a matter of law. They can't indicate anyone under this because it goes beyond what ANCRA says they can do. What ANCRA says is actually a neglected child. And so we were making this allegation. The standard, which has since been changed thanks to our litigation, was for inadequate supervision was it occurs whenever a child was placed in a situation or circumstances that are likely to require judgment or actions greater than the child's level of maturity. I think alternative synonyms for that phrase I just read could be growing up, learning, my childhood. So it really wasn't a very good rule. So we were making this legal argument. And in this case, I'll get back to that. So in this case, the witnesses were, for DCFS, all they had was a hotline reporter and the investigator. Our case, both appellants, and they were a married couple. Sometimes the hearings are separated, but they had no adverse interest, so they did the hearing together. They had the character witnesses. They had a police officer who knew the family and also knew this hotline caller who could vouch for them. And for exhibits, we actually had a few in that case. You might have a case you may not have any documents. But they had sort of an L-shaped backyard. So somebody walking by could have seen the kiddie pool and the kids and not seen the parents. So they had the Google map printout and all of that. And what ended up happening in this case was Melinda, the mother, was expunged following the hearing. But Jordan's finding was affirmed. And so the pro bono attorney in that case was able to continue on and filed the recourse there is filing an administrative review action in circuit court, which even though it's in the trial court is like a mini appeal with briefing and oral argument. And we ended up getting we got a successful ruling in that case following briefing and oral argument, and the judge decided the facts on two grounds. The facts did not support this finding at all. The finding against Jordan should be expunged. But much to her surprise, and I wish we had a court reporter there that day, but we didn't, she ruled, yes, allegation 74 is void. It's outside the scope of ANCRA. So all we had was our little written state court order saying that, but DCFS basically ignored it. They continued to use allegation 74. But this overbroad phrasing, this allegation 74 that I read earlier, has been very problematic. And now we at least had the state court order. So we filed a class action lawsuit, Jones Davis lead pro bono counsel, in September 2016. And we actually just had the settlement approved Monday of this week. After we filed the lawsuit, DCFS changed the rule. They don't have that rule anymore. Now to indicate somebody for inadequate supervision, they have to show blatant disregard on the part of the parent and actual risk of harm to the child, which is what the statute said they should have been doing all along. But that was a huge victory. The procedures have been totally rewritten for allegation 74, thanks to us filing that lawsuit. So that was a huge victory. And so going forward, there's a better rule. In this case that we just settled on Monday now, everybody who was indicated during a 5-year period under the old rule can submit for a re-review of their finding and possibly get expunged. So that kind of thing doesn't happen every day, so it was a big week around FDC, and it all started with Jordan's case. It started with the administrative hearing, and if we wouldn't have lost, we wouldn't have even gone to circuit court and gotten that ruling, and it turned out to be one of our best arguments in support of that class action. So I never know where it will lead. And Rita is going to talk about the other case examples.
Yes. Okay. So Eva's case, again, where her son fell off the bed, burned himself on the radiator. This is a case that, had there been a different investigator, probably wouldn't even have been indicated, because the investigator's own notes showed that she was asleep at the time. Most DCFS workers, who can be very unreasonable, will recognize that it's not neglect to go to sleep while your child exists. So that's basically what she was indicated for. But in this case, there was a really bad investigator. The hotline reporter at the school was also really biased. She made all these weird allegations of abuse and neglect on the hotline call, and then when she was later interviewed, just didn't bring any of those up. So there was some sort of contention between Eva and this lady at the daycare. And then, ultimately there was no disagreement on the key issues of fact. DCFS wasn't saying that, she wasn't asleep or that he hadn't burned himself on the radiator. They weren't saying that there was any medical neglect involved in the way that she treated the burn. And yet they still, they said all of this, she was asleep, the burn was accidental, she's indicated. So in this case, where there's really no disagreement on the key issues of fact, and it's really clear that the standard for neglect was not met, this was a great candidate for a request for voluntary unfounding, and that is actually what happened in this case, that it was voluntarily unfounded prior to the hearing. The DCFS attorney took a look at it and was like, you know what, you're right, this is ridiculous, there's no evidence here to meet the standard, so I will agree to get rid of it. And that was a great outcome. When it's possible to get a voluntary unfounding, it can be sad for the pro bono attorneys because you guys don't necessarily get to go through, do your whole hearing, but it is a great outcome for the parents because you have a guaranteed unfounding, which you never have at the hearing. And then also they don't need to sit there and have somebody critique their parenting skills for a whole day, which can be very difficult. So, and just to point something else out, the specific allegations, the allegations are all different in their format, which is really unfortunate. Allegation 74 and allegation 60, which is environment injurious, those are the two sort of catch-all allegations that we've actually sued on. Those both contain the actual definition for neglect in ANCRA. but every neglect allegation needs to meet that definition. So there's some allegations like bruises. I think like broken bones, like head injuries, they just describe what a head injury is. So you would think that somebody would look at that and realize, like, oh, there's a part missing. I need to go look at the law to figure out when a head injury is neglectful. But there's a lot of people who work at DCFS who are not great at logic, and they will be like, there is a head injury, you are indicated. Like, they're like, sorry, there's nothing I can do about it. I've verified there's a head injury. That's all I need to do, which is not true. So that's just important to remember. Even if your specific allegation does not contain the language of blatant disregard, that is still the language that applies. And so you should always go back and look at INCRA, the Abuse and Neglected Child Reporting Act, look at the definition, especially for neglected child. For abuse, they tend to be a little more specific. But, it's good to look at that, too. And we get fewer abuse cases. We were struggling even to come up with examples of cases with abusive allegations because most of the allegations are neglect. But, yeah, it's always important to go back to that standard. Okay, what actually happens at the hearing? So, first of all, the hearing is not in a court. It's an administrative hearing. It's in a conference room that is much less nice than this conference room and probably doesn't have any windows. But the administrative law judge isn't dressed like a judge. They're just an attorney. They're dressed like an attorney, wearing a suit. And it is a confidential, closed proceeding. So the only people who are allowed to be in the room during the hearing are the ALJ, the DCFS attorney, you, and your client. Witnesses can come in and testify, and then they have to leave once they're done. Is there anything else to say about it? The whole thing is recorded. There's no court recorder. Everything is recorded on just this little digital recorder, and the record is kept in Springfield. And the pre-hearings are recorded as well. And the ALJ will usually give a little spiel explaining that at the beginning of the pre-hearing and then also at the beginning of the hearing. The ALJ will also usually, when he or she opens the hearing, will ask if there's any motions or procedural issues to address prior to moving on to the actual witness statements and everything. Sometimes you will have a motion. Usually, if you're going to have a motion you want to bring up, you want to file that ahead of time, and it might be addressed at the hearing. Maybe if there's something that pops up, you're surprised by something by DCFS, you could write a motion and just bring it to the hearing. But it's not a good idea to expect the judge to just read a motion that you just gave her. So motions might be to exclude evidence, to exclude witnesses. Those would be the main ones. Maybe there could be another type of motion that would come up, and of course, if that's happening in your case, hopefully we would be having discussions about what that might be and how to do that. So if you do have a motion, you'll address that at the beginning. If not, and in most cases you won't have one, the ALJ is required, unless you waive it, to read through the definition of the allegation and also to read out all the rights that the appellant has in the hearing. So it's a really good idea to sit your client down ahead of time and go over those so that you can waive it. Because otherwise, you're just sitting there and she's reading through a packet that's this big. I think it makes them a little annoyed. They don't get too annoyed because they recognize that they have to do it, but if you can avoid it, it's better. So after that, you'll move on to opening statements. As we said, DCFS has a burden of proof, so they present their case first. They'll give their opening statement first, then you can give yours. You always want to give an opening statement. DCFS will usually always give an opening statement as well, although sometimes they won't give closing statements in your opening statement. And we've got more details on all of these parts of the hearing in the pro bono manual. The opening statement is just a little preview of the evidence you're going to put on. It's not necessarily the time to break down the statute and say why the case doesn't meet the requirements in the statute. That's more a closing argument thing. So after you give your opening statement, DCFS will put on their case, then typically you'll put on your case. But in these hearings, you'll often have shared witnesses. So the judge will often ask, if you have a witness on your list that DCFS also has on their list, if you guys can just do it at the same time. Like, I'll allow liberal cross-examination so that we don't have to recall the witness. Sometimes the judge will offer that. Sometimes you'll want to bring it up yourself. You know, I mean, if you have the right to not do that. You have the right to say, I want to recall the witness. But in most cases, you know, why not just get it over with? Most of these witnesses are, you know, there's no reason that you would necessarily need to recall them, except for your client. So DCFS will sometimes call your client as their first witness, which always throws clients off a little bit. It's good to prepare them for that potential situation. And again, this is a judgment call for you, but we would normally recommend that you do whatever cross-examination you need to do to respond to the specific questions that DCFS has brought up there, but reserve your actual questioning of your client for the very end of the hearing when they can address anything that might have come out through other people's statements. So, you know, somebody says, like, oh, they did this, and you've already done all their testimony, you know, that's annoying, and then you have to tell the judge, oh, no, actually, I want to recall them. So it's better to just let them sort of close out the day and give their testimony addressing everything everyone else says. Yeah, so here are some objections. I'm sure you guys know about objections. Sometimes people ask me, like, should I make objections at administrative hearings? Yes, you should make objections. The DCFS administrative rules say that the strict rules of evidence don't apply. That doesn't mean that rules of evidence don't apply at all. What we think that it means, basically, that the judge has discretion to allow in the testimony of the hearsay statements of children that if they're about abuse or neglect. The judge sometimes thinks that it means that they can let in any hearsay statements they want and any evidence they want that's not competent under the rules of evidence. But in addition to being governed by DCFS administrative rules, as an administrative hearing in Illinois, these hearings are also governed by the Administrative Procedures Act, and the Administrative Procedures Act says the rules of evidence apply. So act as if all the rules of evidence apply with the knowledge that, you know, there is this specific hearsay exception for children's statements regarding abuse or neglect. So, you know, understand that those will be allowed in, but all the other objections, you should just go ahead and make them. If the judge overrules you, you've made your record, and we do take cases to administrative review a lot. And so if you want to make your record, if there's some sort of egregious behavior by the judge, they're allowing in terrible evidence, they're allowing in terrible statements, you want to object to that because otherwise you've waived your objection. The DCFS investigative file is in bold. That is their main piece of evidence that they admit. We think that they should not be allowed to admit this. There is no reason they should be able to admit it. It's all hearsay. It's all unverified hearsay. Most of it is double and triple hearsay. It's like somebody saying, it's the investigator writing down, somebody told me that another person told them this. So just the worst kind of evidence that you learned, like in law school, this shouldn't be allowed. It's going to get in. They recently changed the rules to specifically give the investigative file as an example of the evidence that the kind of evidence that the DCFS ALJ is allowed to allow in, but you should make your objection to it anyway. We actually give all pro bono attorneys a sample objection, a sample written objection. Usually we would say just do a verbal objection when DCFS tries to admit it. Basically the objection is it's hearsay, it's not a business record. There's case law that demonstrates that it's not what's considered a business record. It's more similar to a police report, which is something that's created in anticipation of punishment, and it shouldn't be admissible as a business record. Yeah, so that's something you are going to object to it. It's going to come in anyway. Oh, one objection that you should make and that the ALJs will uphold often is objecting to any hearsay statements by adults who are not going to testify at the hearing today. To say, Judge, you know, I understand you're admitting this in, but I would especially like to object to any hearsay statements by adults who are not testifying today being considered for the truth of the matter asserted. So DCFS has the right to bring these people in as witnesses if they wanted that testimony to get in. They haven't called them. There's no hearsay objection that allows that in. And often the ALJ will sustain that. Beyond the scope of prior exam, sometimes that's relevant. Sometimes it's not as relevant if you are calling the witnesses, if you're questioning the witnesses out of order. So if you've agreed to just get the examination over with, have liberal cross-examination to avoid having to recall the witness. Sometimes you might want to make this objection, but often it won't be as relevant. Yeah, and then, make your closing argument. Always make your closing argument. DCFS will waive theirs sometimes, but you should never. This is when you get to point out to the judge everything you think you've proved during the hearing, and that's when you want to say, this doesn't meet the standard. This person testified to this. This person testified to that. It's clear that this doesn't meet the standard under the law.
Under witnesses, quite often a doctor will be called in. They won't have to be the person. They'll call in and give their testimony. That's pretty much all juries kind of go like that.
Yes, and that we do have some more information on that in our pro bono manual about telephone testimony. But yes, it is normal for doctors and certain professionals to give telephone testimony, and they've actually that's part of the Rule 336 change as well. That's been codified as the presumption that for doctors and other professionals, they will give telephonic testimony.
Okay, I'm going to wrap up quickly because I know we've gone a few minutes over. Thanks for your patience. What happens, we did want to add one thing. The spiel that the judge gives at the beginning of the hearing, if you haven't had your opportunity to go over that with your client ahead of time, I would say, yes, Judge, we want to hear that. Or sometimes I have a client who's kind of particularly nervous, is confused by the process, and I actually find it's really good to have the judge kind of read, here's what's going to happen, here's when you can expect a decision. So it's a judgment call. But you don't get an immediate decision. The ALJ writes up an opinion and recommendation, sends it to the director of DCFS who has the final say, and you'll get an opinion, a final decision in certified mail. They have at most, regardless of how many days or the clock prior to the hearing, they have at most 60 days from the day of the hearing to sending out that final decision. And an adverse decision, in your pro bono engagement, you're not obligated to carry on with an appeal. Usually we have a discussion, is there a good case for appeal? Does the client want to continue? Does the pro bono attorney want to continue? It is an option, and many people do decide to appeal, and you have to file a complaint and administrative review in circuit court within 35 days of the date of the DCFS decision. The complaint itself is very simple paperwork, and the briefing comes later after DCFS has transcribed all of the hearings that were recorded, and they provide that to everybody. So that's sort of a case-by-case determination. And then just really quickly, this was about expungement hearings, but we do have attorneys do the administrative review actions after these. Appellate litigation could follow from there. The class action and civil rights cases that we do. We've done some amicus briefing in the past, so there are other opportunities. And Liz is just going to close with a really quick example of the appellate case that she and Bill Essig did here. And then hopefully everybody got a handout. We currently have 3 pro bono cases available, and the case summaries are in your materials. So if anyone's interested in those, please contact us, and we'd love if you were there to take one of those cases.
Oh, yeah, so just about Rosemary C. It was a great opportunity. Isabel Coombs and I worked on the briefs. We did not have an oral argument because it was an expedited matter, but there was an evidentiary issue. The ALJ had let in some medical records without any foundation, and there's very specific statutory requirements for medical records and proceedings like this that had not been followed, so we were able to get the decision reversed and the case remanded for a new trial.
Yeah, it was a really fantastic result, and difficult and unusual to really win those appeals, so great work there. Also, I should have asked if anyone has any questions. Comments, concerns? Okay. Oh. Yes, so pro bono, our guidelines are, and we found the guidelines that most firms follow. If their income has to be 250% or below of the federal poverty guidelines. So we get that information from them, and if they meet that qualification, they're eligible for pro bono. There are circumstances where technically they may be higher, but they have some extenuating medical bills, or or they were fired because of this, and they don't have that income that technically they had it for part of the year, where a firm will be willing to take their case.
What would be the average span of time for someone cases was?
Oh, thank you very much. It's a very good question. Another reason people find these appealing is they normally resolve within a few months. Normally when you take the case, you'll have a pre-hearing or multiple if there are medical records you need to collect or something, or an expert you need to contact. You might have one or two pre-hearings, set a hearing date, and that usually happens. It can be very quick if you're ready and want to do it quickly. It can happen in a month and a half, but even longer. I mean, they're usually done in 3 months or so, or unless it's a really complex case, sometimes they will take longer. But it's a fairly quick turnaround. And then it'll be an additional up to 60 days until you get your decision. But it's a fairly short time period. That's a good question. Thank you. Okay, really quickly, we even just wanted to mention our Young Professionals Board for people who are interested in doing more than just a pro bono case.
That's amazing. I want to mention we have one. We actually had a flyer that was part of the materials. I think more people showed up than I anticipated, so I only had 20 of them. But if you guys are interested, definitely reach out to me. I've got cards if you want one. The Young Professionals Board, if you're not familiar with the setup, it's actually a committee of our general board, and the purpose is to support the organization through fundraising and outreach. It's a great opportunity to get involved in the organization, learn a little bit about being on a board, and the time commitment is really minimal. We actually have a Young Professionals Board member here if you want to talk to her, ask her any questions you want. Yeah, and it would be great to have you. If you guys are summer associates, we don't have anything against law students being on our YPB if you're interested, so definitely reach out to me.
Thank you everyone for coming, and there are